A very good evening to all of you. Friends, the civil service aspirants, most welcome to my channel, News Simplified. Today I am going to discuss with you a very important topic, and this is Article 221 of the Constitution. As you know, the third part of the Constitution contains fundamental rights. Fundamental rights are those rights which are very crucial for the sustenance of life in a dignified manner on the part of the citizens of the country. They are inseparable from the citizens, and they are to be protected with sanctity on the part of the courts, states, and the governments. That is why it is so crucial for us to discuss on fundamental rights. But I am not going to discuss the whole of fundamental rights here. I am going to discuss with you on a very important aspect of the fundamental rights, that is Article 21. Article 21 in the fundamental rights guarantees a right to life and personal liberty for its citizens. A right to life and personal liberty of its citizens. Every citizen has a right to life and personal liberty. He may choose the kind of life he wants to, uh, the kind of life he wants for himself. There is no restriction on your choice of life as you wish. There is no restriction on your personal liberties. These cannot be taken away without following a legally prescribed criteria. If they are to be taken away, they are imperative to be taken away. There are some prescribed rules for them for that, and they cannot be violated at random, arbitrary, on the part of others and on the part of the state itself, the government itself. You may ask, during corona time people were deprived of their personal liberty. They were holed up, they were confined to their homes. Why was it not a violation of personal liberty, the very crucial uh, aspect of fundamental rights? No, it was not the violation of personal liberty, and no attack on the life of its citizens, because it had a very clear cut aim to protect the life. When the governments are protecting your life and are putting restrictions on your personal liberty, they cannot be called violation of human rights or a violation of uh, right to life. Let us see, fundamental rights are applicable to all in the same way. Right to life and right to liberty, personal liberty, is also a fundamental right available to all its citizens and non-citizens as well within the boundaries of the country. Those citizens of other nations, foreigners who are living in our country, they are also provided with the right to life as a fundamental life right to them also, as long as they remain in the boundaries of the country. The article primarily protects individuals against state action from arbitrary actions. Yes. Now, it is to be noted that this article protects the individual right to life and liberty from any attack on the part of the government, from any attack on the part of the state. But what if the individuals attack the other individuals' right to life and liberty? That becomes a crime. But until there is a reasonable restriction on the liberty of the person, they cannot be brought under the Article 21. Suppose if a father puts restrictions uh, on his sons to a reasonable extent on the uh, on their freedom, on their private liberty, it does not violate the very concept of the right to life and right to personal liberty. But it should be to a reasonable extent and not go beyond that. Otherwise, that will become a crime. That will become violative of the fundamental right to life and personal liberty. Now, one thing to be noted here is that the Supreme Court judgments from time to time have expanded the scope of Article 21. Article 21 is not just confined to right to life and personal liberty alone, but they have expanded their scope and are applicable to all other matters as well. We will have a look at them as well. Right to livelihood is also a vital part of the right to life. It means the citizens of the country have a right to earn livelihood, they have a right to bread and butter, and that is why they have right to employment as well. It is the duty of the state, the duty of the governments to provide means of livelihood, and they come from providing employment to the citizens. So this is also a crucial, a very important part of right to life and right to liberty. Right to privacy, it means every citizen of the country has his private space in life. You have some private details of your life. This is your some of there are some of the private secrets you have about your choices, about your food, about your clothing, about your uh, indoor habits, not public habits, indoor habits. They are not to be divulged in the public, and you are safeguarded and protected against that as well under this Article 21. One thing to note as well is a right to a speedy trial. All the citizens of the country have a right to a speedy trial. It means if the courts prolong trials and justice is not done in a speedy manner, that is also a violation of the fundamental right to life and liberty as well. But as you know, things are not respected as they should have been respected. There are rules, there are so many provisions in the constitution, but respect to them on part of the governments and states is not as it is expected. It is still lacking proper implementation. Right to compensation is also under Article 21's right to life and liberty provision. Right to compensation. It means if your fundamental rights have been violated, you should be compensated for that on the part of the state and the governments. It is also a fundamental right for the citizens. Now, I want to draw your attention to a very important judgment made by the Supreme Court. The judgment is a landmark judgment. The judgment is called M.K. Ranjit Singh and others versus Union of India. M.K. Ranjit Singh versus others and others versus Union of India, in which Article 21 has been stressed to include the right to be free from the diverse adverse effects of climate change as a fundamental right. Yes, as you all know, global temperature is rising. Climate change is visible to all, and it is impacting the lives of all, whether flora or fauna, or are being adversely impacted, negatively impacted, and this is accepted from scientists to the general public, the common people, that this is an intervention in the healthy uh, lifestyle and healthy uh, way of living, and the court directed the government to provide its citizens safeguards against the adverse impact of climate change and global warming. It means that the governments cannot be reluctant to take proactive measures to protect the health of its citizens. The adverse effects resulting from the global warming and climate change have to be addressed by the governments, and it is the responsibility of the state to provide mechanism to protect the health of the people against the onslaught of the climate change and global warming. That is the reality of the modern life. When Delhi was choked by air pollution, the court recognized right to clean air as right to life under Article 21 of Constitution. Right to clean air was accepted as a right to life and right to liberty under Article 21 of the Constitution. It fell under it. The pollution level rose in Delhi, and the Supreme Court delivered its judgment to protect its citizens and make the air of Delhi breathable for its citizens, so that they are not deprived the very important right to clean air. Clean air is also a right to life as well under Article 21 of the Constitution. In July 2025, the Supreme Court gave its landmark judgment in Sukdeb Saha versus State of Andhra Pradesh. In this judgment, the court acknowledged right to health as a fundamental right to life. Yes, Sukdeb Saha judgment. Sukdeb Saha judgment. I am going to delve broadly on this very judgment. I am going to tell you the story behind Sukdeb Saha judgment which came in July 2025. It is called Sukdeb Saha versus State of Andhra Pradesh judgment, which was passed. A person had a 17-year-old daughter who was preparing for NEET exams. One day, she committed suicide, and the father filed FIR. The police launched an investigation, but the local police investigation was not satisfactory to the father. So he filed uh, a case to get CBI inquiry and investigation done on the causes and the kind of circumstances that led to the suicide of a brilliant child. And after that came this judgment, Sukdev Saha versus State of Andhra Pradesh. In this landmark judgment, the judges acknowledged mental health as being an integral part of the right to life under Article 21 of the Constitution. Yes, mental life is also an integral part of right to life under Article 21 of the Constitution, which we are discussing here. You know, there is a growing number of students committing suicide, and reports come sometimes in bulk from places like Kota and other places that students are committing suicide. And this has become a modern day phenomena when the stress level and the pressure on the minds of the students is rising day by day. The students who are preparing for exams go through a lot of pressure. From criminological perspective, the case highlights what can be termed structural victimization. When we look at from criminological perspective, this uh, scenario of student suicide falls under a structural victimization. It means there is a structure of making students victims of the system. They are being victimized. And the role of the state can also not be denied. It also has failed to pay proper attention to the mental health of its bright young generation and citizens of the country, the young sons of India. What are the conditions which drive the student to take their lives? Exploitative culture of coaching centers and the indifference of schools and universities produce an environment where young people become vulnerable to harm. An atmosphere has been created in the coaching institutes, educational institutes, and competitiveness, a false competitiveness, a kind of a enforced competitiveness is being given as a reason to safeguard themselves from onslaughts. When they are criticized, they take this as their rational to save themselves. So there is an exploitative atmosphere in the coaching institutes and the institutions, and by failing to provide safeguards, the state and institutions become complicit. They are also involved. They are also hands in glove with the others in driving the bright student to take his life by pushing the students to the brink that they take their lives, they commit suicide. This is what the judgment says. The gaze of victimology, which has been examined, the dynamics between victims and perpetrators can be extended to state institutions as de facto perpetrators. It means the state cannot escape from their culpability, from their responsibility, and they must be brought under the ambit of the and the scope of being the perpetrators of such crimes. If you are not curbing the kind of a exploitative atmosphere that is prevalent in the country or the state, you are walking hands and gloves with those who are the criminals of the system. Students are not just victims of internal psychological battles, they are the victims of an educational system that treats them civilly. The system of the education treats them civilly, and that is why they are taking such extreme steps of taking their lives, committing suicides. It is also social erosion of social values as well. A very important thing to note here. Suppose you are a student from marginalized section of the society, scheduled caste and scheduled tribes section of society, and you are studying in a premier institute of the government or a private institute, whatever it will be, it doesn't matter here. If you are studying there, you are mixing with, you are mingling with the students, your peers in everyday life, and they do not treat you well. Sometimes caste slurs are thrown at those students. Sometimes they are maltreated, not treated well. This brings down the dignity and discourages the very student. He feels stigmatized, he feels victimized by the system, and he can be driven to the extent of taking his life, and he finally commits suicide. That is the testimony to a loss of social values in society, which puts hierarchy as a precondition for a right to live with dignity. Hierarchy is put as a precondition for a right to live with dignity. Here is the problem. We are living in a society where hierarchy matters, caste system matters. Why can a scheduled caste or scheduled tribe student not coexist with the students of the upper caste? Does he not have the wish to live with dignity? And if he cannot coexist in a very premier institute, this is the lack of, it can be called as a erosion of social values as well. Legally, uh, set it aside, sometimes these cases are confined to personal bereavement. If someone has taken his life, so if someone has committed suicide, it is a personal loss of a family, personal loss of a student, and it is not given an expanded scope that someone has aided and abetted in that. Sometimes the governments are not uh, made responsible for such horrific incidents. It, but the court ruling recast problem not as a personal bereavement but as a public injustice. In this case, it has been said by the Honorable Court that it is not a personal bereavement but a public injustice. If such a crime, due to these reasons, occurs, it will be called a public injustice. There are provisions to support the mental health of its citizens. There is an act actually, the Mental Health Care Act 2017, which enshrines the right to receive mental health care. But it has not been implemented consistently, and enforcement mechanisms are still poor. By entrenching mental health in the Constitution, the court has established an elevated normative benchmark. Citizens can insist on safeguarding their psychic health as a fundamental right, not just as a statutory right. Mental health in the Mental Health Care Act 2017 has been ensured as a fundamental right, but due to many reasons of not being implemented uh, properly in practice, uh, it still lacks its force as it should have. After this landmark judgment, the court gave directions to the state, to the governments, that say they should evolve a mechanism, they should develop a mechanism so that the life of such students are protected, and the governments came up with Saha guidelines. Saha guidelines. Remember the name Saha guidelines, and because of that, here in schools, colleges, hostels, and coaching institutes, they are required to proactively develop support system to address the issue of mental health. The schools, coaching institutions, and even up to the level of IITs and medical colleges, there is a mechanism to keep counselors and psychologists to deal with the mental problems of the students which they face on a day-to-day basis. It is because of that Saha guidelines. If suicides among students are partially an outcome of institutional neglect, can this form of neglect be regarded as a structural violence? If students are committing suicide, can this be a form of neglect as a structural violence? Can it be called structural violence? Suppose this is an environment of a kind of a violence. It means everybody is involved in this violence. If a student commits suicide because of some social injustices that are meted out to them in the institutes on the part of his peers, it means the colleagues, it means the college going students who are his friends of upper caste and maltreating such students, and they commit suicide on that reason, or there is an exploitative atmosphere in the educational system that is pushing them to the brink of committing suicide, everybody is culpable, everybody is involved in this crime, in this violence. This can be called a structural violence. According to sociologist Johann Galtung's theory of structural violence, societal structures causing systemic harm to individuals by depriving them of basic needs are equally blameworthy as direct violence. It means direct violence. If you choke someone's uh, breath and kill him, if you shoot someone and kill him, it is a violence, it is a crime. But if you are helping indirectly in the commitment of such crimes, it is also a crime, it is also a violence, and this is called structural violence. If you deprive basic needs, you are equally blameworthy as direct violence. You are aiding and abetting violence. Sometimes individual failures are just they are called individual failures. The student was failing in his exams, and that is why he committed suicide, and it is brushed under the carpet. These do not go to the level of establishing that it is the result of systemic injustice. It does not go to the level of establishing such a suicide as a systemic injustice. Placing psychological integrity in Article 21 means that the court has opened up from these victims to be heard and safeguarded. When it has been brought under the Article 21 of the Constitution, the fundamental rights of such students are being safeguarded and they will be heard. They will not feel the stigma of being deprived of the proper conditions which are putting pressures on their minds to go to the extent of committing suicide. So now the protection on the part of the governments and the state will be provided, and failing which they can be brought to court, and the court will decide who is the culpable side. Restorative measures can be taken now: counseling, reform in institutions, mechanism of accountability, and that go beyond retribution to prevention. Now, with uh, this kind of a mechanism, when Article 21 has been brought under fundamental rights, under Article 21, it has been protected under Article 21. This is going to be properly taken care of by the courts and the states as well. Powerful judicial pronouncements cannot by themselves uproot established cultural and institutional norms. The challenge is whether schools and universities and state governments will meaningfully apply the guidelines, invest in resources, and train personnel to deliver real mental health care. Now, the universities, colleges, and the governments need to invest in training of psychologists, mental experts, so that the lives of students are protected from such violence that is prevailing in society at this time. Ultimately, Sukdeb Saha represents a convergence of law, criminology, and victimology. It acknowledges that students are often treated as passive subject of education. This is the flaw of our educational system, that we treat the students as passive subjects of education. We don't we put pressure on the student to choose science instead of humanities. We, as parents, as guardians, expect from the student to excel in science and mathematics when he has a liking to write poems and he is very interested in drawing. Why are you putting such a pressure? You are going to be culpable of adding and abetting a crime if the student is pushed to the brink to take life. It challenges society to confront an uncomfortable truth that neglect, indifference, and structural pressures can be as deadly as acts of direct violence, in affirming that the right to life must include a healthy mind. Right to life must include healthy life. You must have freedom, not a physical freedom, but a mental freedom as well. You can freely enjoy your life, your liberties, your studies, and you can live with dignity in your society in which you are living. This kind of an environment, this kind of an atmosphere, if created by the state, can support a good mental health of its citizens. Uh, Now we are going to conclude here. The judgment remains a beacon of hope or a missed opportunity. Let us see whether this judgment, Sukdev Saha versus state of Andhra Pradesh, uh, is a missed opportunity or a beacon of hope. It means some positive changes are going to happen in near future. or we are going to miss the opportunity. To conclude this video, I want to tell you that this is very important matter. Mental health is very important. When incidents like uh, students committing suicide are seen by us, we are mentally perturbed, but we don't go deep into the crisis. We sometimes neglect it, or sometimes brush it aside as a personal loss, as a personal failure. These issues are not taken seriously by the people and the governments at large. But now, when Article 21 applies to them all as a fundamental right, it is the duty of the state to safeguard the mental health of its citizens. With this hope that the future will be bright for such bright students, I conclude my video. Thank you for watching my video.